and you, Honorable Breitenbach.
Fine, thank you.
Thank you. I think it's important for us to start. The last time we met, we were doing interviews for the position of the Deputy Public Protector. And there were issues that needed legal advice. We asked the legal advisor to go and do a detailed legal advising, namely one on the issue of reasonable apprehension of bias, to the issue of conflict of interest, the issue of recusal, and for the fact that Honorable Mkhwebane is not the sole decision maker in the panel. So the legal advisor asked for more time, because at the time that we asked for the legal advice, we really ambushed her. We gave her some few days. It was on a Wednesday. We gave her until Monday to give us the legal advice, which she complied. We received the legal advice that Monday, but we could not meet that particular week because of that 30th anniversary of the Constitution. And the following week, the House was starting at 10 in the morning. So we are meeting today to receive that legal opinion, which will assist us with the way forward. Is the legal advisor present?
Good morning, Chair. The legal advisor is present.
Thank you very much. Welcome to the legal advisor. Can you proceed? Thank you very much. Can you proceed with the legal opinion?
Good morning, Chair. Thank you. Good morning, honorable members. As you will recall, I was given until the 18th of March to share.
Show your face. Can you show your face, and then you can close it thereafter?
Okay, I will, Chair. Good morning, Chair.
Thank you very much. At least we are talking to a person, not to an AI program.
Indeed.
Thank you very much. You
Thanks,
can.
Chair.
Sure. You can proceed, Ms. Zenani.
Thanks, Chair. I'm hoping to share my screen. Maybe Sia may indicate if it's showing.
Yes, it is showing.
Thank you, Chair. This presentation is based on the opinion that was shared with the committee on the 18th of March, pursuant to the request that was made from legal services on the 13th of March to provide a legal opinion on the issue of the recusal of Advocate Mkhwebane from the Deputy Public Protector selection process. So my presentation is an extract from the legal advice that was shared on the 18th. So I'll start from slide number 2, where we say the Portfolio Committee on Justice and Correctional Services currently seized with the selection process for the position of a Deputy Public Protector requested a legal opinion on whether Advocate Mkhwebane should recuse herself from the process due to the existing relationship he has with two of the candidates, Advocate Shadrack Tebeila and Ms. Ponantshago Mogaladi. The full legal opinion was submitted to the committee on the 18th of March, and the background and circumstances in which the legal opinion was solicited are set out in that opinion. Chair, this presentation will therefore focus on the facts that arose during the deliberations by the committee on 13 March 2024, which is the day on which the interviews for the position were conducted. As a background, Chair, the facts that emerged insofar as the two candidates are concerned are that Advocate Tebeila is currently representing Advocate Mkhwebane on a pro bono basis. We understand from the brief that it is a matter that is currently underway before the African Court on Human and People's Rights, and that it is Advocate Debeila who approached Advocate Mkhwebane to offer his services pro bono. This matter relates to Advocate Mkhwebane's impeachment proceedings, which she continues to challenge in various courts. And so far as Ms. Mkhaladi is concerned, she is the executive manager in the Office of the Public Protector. She was charged and found guilty of gross misconduct during Advocate Mkhwebane's tenure as the Public Protector. A sanction of suspension and docking of salary for a period of 3 months was recommended by the chairperson. Notwithstanding the recommended sanction, Advocate Mkhwebane wrote to Ms. Mkhaladi informing her that she was imposing a sanction of dismissal with immediate effect, subject to the filing of representations. Ms. Mkhaladi approached the Labour Court seeking an order interdicting the Public Protector from invoking what she termed a secondary disciplinary process on sanction, as this was ultra vires the Public Protector's disciplinary code and procedure. The order was granted in Ms. Mkhaladi's favor, and in deciding the matter, the presiding judge, Judge Tlotla Maje, remarked, the applicant, and I quote, the applicants concerned that the Public Protector has already decided their faith are not misplaced. The Public Protector specifically stated in her letter that she is hereby imposing a sanction of dismissal with immediate effect, subject to receipt of their representation. It was submitted on behalf of the Public Protector that the court must accept the bona fides of the contents of the letter. The court will, however, be hard-pressed to do so, based purely on the plain reading of that letter. The application for leave to appeal this judgment was dismissed with costs. Furthermore, and in respect of Ms. Mkhaladi, the Section 194 inquiry into the fitness of Advocate Mkhwebane to hold office made findings of victimization, intimidation, and harassment on Advocate Mkhwebane's part against Ms. Mkhaladi. On these facts, the Constitutional and Legal Services Office was asked to provide an opinion on whether there is a conflict of interest and perceived bias warranting Advocate Mkhwebane to recuse herself from this process. The issues that we identify from these facts are as follows: whether or not the relationship between Advocate Mkhwebane and the two candidates creates a perception of bias and a conflict of interest, and if so, whether the circumstances warrant her recusal from the interviews of these two candidates. The legal framework applicable is Section 57, subsection 1B of the Constitution, which provides the National Assembly may make rules and orders concerning its business with due regard to representative and participatory democracy, transparency, and public involvement. So, consequently, the NA rules were enacted, and the rule, the provision that is relevant for this purpose would be Rule 30 of the rules, which states that if a member has a personal or private financial or business interest in any matter before a forum of the assembly of which she or he is a member, he or she must, at the commencement of the engagement on the matter by the forum, immediately declare that interest in accordance with the code of conduct contained in the schedule to the joint rules and comply with other provisions of the code. So the relevant provisions of the code that need to be complied with are Clause 5.1, which states that, well, the code that we're talking about is the Code of Ethical Conduct and Disclosure of Members' Interests for Assembly and Permanent Council members. It's Clause 5.1 states that a member must resolve any financial or business interest, business conflict of interest in which he or she is involved in his or her capacity as a public representative in favor of the public interest. And she or he must always declare such interest, and where appropriate, the member should recuse himself or herself from any forum considering or deciding on the matter. Clause 5.2 of the code also states that, Clause 5.2.4 states that the member must declare any direct personal or private financial or business interest that that member or any immediate family of that member or any business partner of that member or the immediate family of that member may have in a matter to be considered or decided on before any parliamentary committee or other parliamentary forum of which that member is a member or in which that member is participating, or withdraw from the proceedings of that committee or forum when the matter is considered or decided on, unless that committee or forum decides that the member's interest is trivial or not relevant. The case law that is applicable would be the famous SAFU decision, where in dealing with the test for biasness, the court stated, a cornerstone, and I quote, a cornerstone of any fair and just legal system is the impartial adjudication of disputes which come before the courts and other tribunals. This applies, of course, to both criminal and civil cases, as well as to quasi-judicial and administrative proceedings. Nothing is more likely to impair confidence in such proceedings, whether on the part of litigants or the general public, than actual bias or the appearance of bias in the official or officials who have the power to adjudicate on dispute. The court in this matter further places the responsibility to determine a recusal application upon the judge against whom the application is made. This, in our view, accords with Clause 5 of the Code, which places the responsibility of the member on the member concerned to make a judgment call on whether it is appropriate in the circumstances to recuse themselves. It must also be noted that the Code deals specifically with members' personal or financial interests, which is distinguishable from political interests where members have expressed their political positions in a particular subject. The SAFU judgment referred to above further highlights that in applying the test for recusal, courts do in fact recognize that legal training and experience prepare judges for the often difficult task of adjudicating matters in a manner that is fair. Be that as it may, in R versus D, the Supreme Court of Canada makes a proposition that courts have rightly recognized that there is a presumption that judges will carry out their oath of office. This is one of the reasons why the threshold for a successful allegation of perceived judicial bias is high. However, despite this high threshold, the presumption can be displaced with cogent evidence that demonstrates that something the judge has done gives rise to a reasonable apprehension of bias. In Mock versus Ned Travel, the court cautioned that on the part of a judge whose recusal is sought, there should be a full appreciation of the admonition that she or he should not be unduly sensitive and ought not to regard the application for his or her recusal as a personal affront. BRT Industries South Africa versus Metal and Allied Workers Union and another, the court said, the court made a proposition that the law does not seek to measure the amount of the judicial officer's interest. The Honorable Judge Hoxter stated that, ventured to suggest that the matter stands no differently with regard to the apprehension of bias by a lay litigant, provided the suspicion of partiality is one which might reasonably be entertained by a lay litigant in a reviewing court. A reviewing court cannot, so I consider, be called upon to measure in a nice balance the precise extent of the apparent risk. If suspicion is reasonably apprehended, then that is the end of the matter. On our discussion, we say both Rule 30 of the National Assembly rules and the Code anticipate an event where a member may have a personal or private financial or business interest in a matter serving before a forum of the Assembly. These provisions are regardless of the member's professional affiliation or oath of office taken by the member. Both the rules and the Code call on such a member to declare certain interest and, where appropriate, recuse themselves from the process. This requirement is aimed at managing any perception of bias insofar as the member's judgment is concerned. A mere perception of bias is not sufficient, we submit. The above case law suggests that the apprehension of bias must be reasonable, depending on the facts of each case. As the case law suggests, judges are legally trained people who have an obligation to abide by their oath of office. This principle applies to members of the National Assembly as well. There can be no doubt that the rendering of the pro bono services by Advocate Debeila at no cost amounts to a financial benefit which is accruing to Advocate Mkhwebane. This is what Rule 30 of the National Assembly rules, read with Clause 5 of the Code, seeks to address. With regard to Ms. Mokhaladi, the Trotalimange judgment questioned Advocate Mkhwebane's bona fides with regard to the wording and tone of the Audi letter, and further confirmed that Ms. Mokhaladi's concerns that Advocate Mkhwebane has already decided their fate was not misplaced. Furthermore, there is a finding of victimization, harassment, and intimidation on the part of Advocate Mkhwebane as against Ms. Mokhaladi in the Section 194 inquiry. This finding still stands until or unless it is set aside by a court of law. As we conclude, Chair, we submit that with regard to whether or not the relationship between Advocate Mkhwebane and the two candidates creates a perception of bias and a conflict of interest, our answer to this is in the affirmative. Based on the facts presented, we submit there is a reasonable apprehension of bias. With regard to whether this warrants her recusal from the interviews insofar as the two candidates are concerned, we refer this honorable committee once more to the provisions of the code, the provisions in Clause 5 of the code, which say that the member must resolve any financial or personal interest. The member must declare those interests, and where appropriate, the member must recuse or withdraw from the process. And we say that we submit that there is the facts presented do warrant a recusal in the circumstances based on the test of a reasonable apprehension of bias as set out in the case law and authority quoted above. Our conclusion stems from in the first instance, the fact that Advocate Mkhwebane is currently deriving a financial and personal benefit from the Debeila relationship. And in the second instance, with regard to Ms. Mokhaladi, the findings of the Section 194 inquiry, read with a totally major judgment, suggests strongly that any reasonable person will apprehend bias on the part of Advocate Mkhwebane, given their history. Both the code and the jurisprudence highlighted in the opinion place an obligation on the member concerned to resolve, declare, and recuse themselves in the circumstances. Our view is that whether or not Advocate Mkhwebane is a sole decision maker in the process is irrelevant to the consideration of recusal, as both the National Assembly rules and the code speak to a personal other than political interest in the matter at hand. If Advocate Mkhwebane persists with her view that it is not appropriate for her to recuse herself in the circumstances, we are of the view that any party that is aggrieved by such a decision will have a right to approach a court of law to have such dispute decided accordingly. The National Assembly rules do not provide for any process or for a process of compelling a member to recuse themselves. However, failure to do so would potentially result in a breach of the code. Given that neither the rules nor the Public Protector Act set out the procedure to be followed for the appointment of a Deputy Public Protector, it is submitted that the following options would be available. Advocate Mkhwebane may recuse herself from the process in its entirety and be replaced by an alternative member of her party, or Advocate Mkhwebane may recuse herself in respect of the interview portion and deliberation in respect of the two candidates and participate in the balance of the interviews. In the event that Advocate Mkhwebane, as we've already stated, persists with her position that she's not conflicted, there's a possibility of a legal challenge being mounted against the committee. To avoid such challenge, this scenario would place an onerous task on the committee chairperson to ensure fairness throughout the process. Chairperson, this is our advice. I thank you.